Hello, today I will be advising you on Tony's claim against you in relation to the injuries he has sustained whilst in your employment. I will then move on to Maria's claim. Firstly, we must determine whether there is actionable damage. Tony's injury must satisfy the de minimis rule. This means, as stated by Lord Hoffman, that damage must be more than minimal. Tony's injury satisfies this rule as blindness is a life-changing condition. Therefore, the physical injury to his eyes is actionable damage and will come under Section 38(1) of the Limitation Act. It will then be questioned whether you owe Tony a duty of care. You omitted to clear the stage. Omissions are different to positive acts. According to Stovin, generally there is no duty of care for omissions. Under this, you may not have a duty of care. This is because the court is reluctant to implement duties where there is no positive act. Lord Hoffman referenced the monetary impact if a flood of claims were to be made against a magnitude of bystanders. Lord Nichols agreed, stating that something more is required than being a bystander. One needs to limit the culture of compensation. However, according to Haynes, the omissions rule will not apply where a source of danger has been created. Tony will argue that you created the danger. You knew that the stage was in use due to rehearsals. You did not take steps to stop this risk. You also had a position of responsibility to Tony. Under Watson, employers have responsibility for the safety of their employees. Therefore, you will have an established duty of care in an employer-employee relationship, as established under Cartledge and confirmed in Rothwell. It will then be determined whether you have breached this duty of care. This will be done using the reasonableness test. According to Vohin, the reasonable test is objective. As outlined by Tyndall CJ, an objective test is the standard of a man of ordinary prudence. In Paris, it was determined that any reasonable prudent man will follow the usual practice. You have failed to clear the stage, which will be standard practice when rehearsals are taking place. Therefore, the court will take your duty of care in respect to any other reasonable employer. A breach of duty of care is likely to be established. It will now need to be shown by Tony that your breach caused the damage. Firstly, you must overcome factual causation. The law will attempt to establish a factual link between the damage and the conduct using the but-for test as established by Barnett. Tony will argue that but for the stone, he would not have suffered injury. To determine liability, your contribution must be more than 51%. The court will use a balance of probabilities on each cause, as acknowledged in Wilshire. You may argue that the stone and or the eye drops, the surgery and or the eye drops were supervening acts to limit liability. However, supervening acts required a second act to be completely unrelated. Both would not have been needed but for your negligent act. As they are related, it is unlikely that you would be able to argue supervening causes. Tony will argue that but for the negligent act, he would not have needed surgery or the eye drops. This is a strong argument. Therefore, it is unlikely that you will overcome factual causation, as your contribution will probably be more than 51%. The second hurdle that you must overcome is legal causation. Was the damage a foreseeable outcome? The Wagon Man No. 1 established that the type of harm could not be too remote. It has to be reasonably foreseeable. The initial injury can be reasonably foreseeable, as it is likely that stones may be kicked into the air when dancing. Tony will argue that the sympathetic ophthalmoma SO may be reasonably foreseeable, as eyes are a sensitive area. Furthermore, he will argue using core that the extent of the harm, his blindness, does not have to be foreseen for you to be liable for the whole harm. However, the law here is inconsistent. In the case of Tremaine, it was deemed that the type of illness and the extent of it was too remote, despite the precedent set in core. Using this case, you could argue that the SO was not a foreseeable outcome, as the condition is particularly rare. The NHS states the risk is between 1 in 14,000. As well as this, we will question whether the doctor explained the risk to Tony involving surgery or the eye drops. This will be medical non-disclosure and may constitute a novus actus interveniens. As established in Chester, a lack of informed consent due to non-disclosure constitutes an intervening act. However, we would need more information to proceed in this area. You could argue that the drops made Tony's condition worse, as they are experimental. As well as this, Tony will have to remove his bandages to administer them, meaning he could have been exposed to further trauma. This may act as an intervening cause. However, one of the functions of tort is to acknowledge relevant policy considerations. It is referenced by Lord Saatchi in the Medical Innovation Bill debate that the development of new treatments must be protected to avoid litigation against them. If there were no protections in place, it may deter further production of experimental but beneficial treatments. It is unlikely that a court will allow this. The surgery poses a better alternative. SO is an inflammation which occurs after injury or surgery. It can develop any time after the initial trauma and can develop in both eyes. You could argue the trauma from the surgery caused the final injury, as it is impossible to discern whether the surgery or the stone caused Tony's condition. This may intervene between your action and the injury. However, courts often refrain from placing liability on medical professionals. In Bolam, McNair stated that a medical professional is not negligent if he has practiced in a way accepted by a responsible medical body. Furthermore, it has been determined by Webb that medical treatment would only break the chain of causation if it was so grossly negligent as to be a completely inappropriate response to the injury. Indeed, it has been referenced by Mayola that medical professionals are unlikely to be held to be intervening acts. The court will weigh up these arguments. Whilst you have a stronger case in this area, legal causation could still be found. If this is so, the eggshell principle, as established by Robinson, will apply, meaning you will be responsible for the whole harm. You may have breached your duty. There are possible defences you can employ against this. Contributory negligence will attempt to focus on Tony's intervening act of administering the eye drops. This defence cannot break causation, but it may reduce the amount of damages you have to pay. This defence is found under the Law Reform Contributory Negligence Act. Core requires that the act of the claimant must be voluntary and informed. Tony was and did voluntarily take the drops. In Spencer, a very high degree of reasonableness was said to be needed. Tony did not act rashly. He acted on medical advice. Sadly, this defence would probably not work. To conclude, you would be likely to be liable for Tony's injuries. We now must move on to the case brought against you by Maria. Maria is bringing a claim in respect to physical damage of mesothelioma. This damage is actionable under the Limitation Act. Your duty of care would not be stopped due to an omission. You have created a danger by omitting to eradicate the asbestos. Maria does not fall under the duty of care established for employer-employee relationship as she is not an employee. However, Maria, under Maguire, will argue that you do have a duty of care towards her. Here it was held that an employer, if they knew the risk, could be liable for secondary exposure to asbestos. Furthermore, it is established in the case of Hennigan that a duty of care would still exist so long as the type of illness was asbestos-induced. It does not need to be mesothelioma. The court will therefore reason by analogy to these cases. You will be judged on the breach of your duty using reasonableness. It is acknowledged in the case of Curry that employers must take reasonable care to prevent the exposure of its employees and members of their family to asbestos. The asbestos is not a risk of small magnitude, therefore it would not be deemed to be de minimis. In Williams, it was stated that you must know of the risk. You could argue that you didn't know of the risk as the article was published only 4 months ago. The court may take this into account. However, it is a fact that asbestos is dangerous. It will be argued by Maria that you should have been aware of the possibility of asbestos. It was acknowledged in the case of Maguire that in the Sunday Times in 1965, long before Bernardo worked for you, it was published that an indication that asbestos could be fatal. Therefore, it will be argued that you should have been aware of the risk of asbestos being present. I feel that you may be able to argue you did not breach your duty, as you did not know of the risk. However, Maria will argue that you knew of a potential risk. If you cannot prove that you did not breach your duty of care, you must show that the breach did not cause the injury. Firstly, factual causation. Maria will argue that but for the asbestos exposure, she would not have contracted her condition. However, the balance of probabilities may overcome this. The only way to overcome complete liability for Maria's condition is through multiple causes argument. Both you and the London Ballet Company, LBC, could have caused Maria's condition through asbestos exposure. It is impossible to know which of you caused it. Her injury is divisible, meaning the dosage is unrelated in this case. You will be liable under factual causation as there was asbestos present in the piping. As Bernardo was a plumber, it is likely that it was on his clothes. Therefore, under Section 3 of the Compensation Act, you may be jointly and severally liable for damages. However, as the condition is not specifically mesothelioma, the condition which the section covers, you may be liable under the precedent set by Fairchild. According to this, as long as the defendants have been shown to have caused the damage complained of, they will have a liability imposed. Under this, only one will be responsible. Alternatively, you may be subjected to proportionate liability under Barker. This means that you will be proportionally liable for your chances of causing Maria's condition. Secondly, legal causation. It may be possible for you to argue that it is not reasonably foreseeable that Maria would be affected directly by asbestos. However, according to Curry, even though Maria did not enter the place of work and instead contracted it from her clothes, it is still reasonably foreseeable that the injury could occur. Therefore, it is likely to be deemed that her injury is not too remote. There are no defences to employ in this situation. It is possible that Maria may succeed in her claim due to previous precedent. However, the courts may consider the policy problem of the floodgates argument, which may stop her claim in order to ensure that there aren't any unwinnable cases coming forward. Therefore, it is likely that you will be liable for both Maria and Tony's damages and may then suffer from liability in this area.